Just family, yeah. So, well, that's all they do.
Good evening, everyone. I'd like to invite you all to take your seats and we can get started right away here. Thank you all so much for joining us, everyone in person and online tonight. My name is Jasper Dent. I'm the event coordinator here at McNally Robinson Booksellers in Saskatoon. This event is being held on Treaty 6 territory. This is the land of the Cree, Dene, Saulteaux, Dakota, Nakota, and Lakota, and homeland of the Métis Nation. It's my pleasure to welcome you to the Saskatoon launch of Prison-Born, Incarceration and Motherhood in the Colonial Shadow by Robin Hansen, published by University of Regina Press. This event will be hosted by Marilyn Poitras. Thank you to both Robin and Marilyn for being here tonight and for working with us to grade this event. Just to note that this event is being live streamed. You may have picked up on that when I welcomed people online. The camera is up to the front over here. It will not be filming the audience. However, it will pick up your cell phone if it rings during the event. So now would be a great time to check that you have silenced that. All right, I'd like to introduce our author and host this evening. Robin F. Hansen teaches law at the University of Saskatchewan. Her work has been published in journals including the Modern Law Review, Global Jurist, and the Journal of Legal Education. She lives here in Saskatoon. Marilyn Poitras is a Michif Irish-Scottish woman born and raised on the prairies. She has a master's in law from Harvard Law School and is a lifelong student of Indigenous laws with elders from home and around the globe. Everyone, please give them a very warm welcome.
So we're going to do a reading first, and then we'll have a discussion with myself and Marilyn, and then we'll do a Q&A with the audience. My name is Robin Hansen, and well, thank you very much for attending this evening. Thank you to those online. This is a topic that I didn't anticipate becoming interested in, but I ended up becoming a mother and becoming interested in new things. So I wrote this book because when I was pregnant, I found out about how when you're incarcerated and you give birth, automatically in most places in Canada, your baby just goes elsewhere, regardless of any sort of aspect of the circumstances. And I found that to be a very draconian, upsetting, and horrendous part of Canadian society. And through talking about it with other people, eventually got involved in representing someone who was faced with that scenario. And thankfully, we managed to avoid that separation happening. It's all explained in the book, all sorts of last-minute scrambling and happenstance. Essentially a thoughtful Crown agreed that it didn't make sense in the circumstances for there to be a separation, and her sentence got converted, as it were, to house arrest. So I'm going to read from the book a little bit of the facts and also a little bit of the theory. And just, I'd like to, of course, do a little bit of thank yous first to all of my colleagues, all of the lawyers, all of the non-lawyers, everyone. I said, how does this work? And they helped me because there was a whole lot of questions to this process. And obviously, I'd like to thank Jacquie, who that's her chosen pseudonym. She was very supportive of addressing this issue, and without her support and input, this book couldn't have happened. So I will first do a brief reading, and then we'll have a discussion with Marilyn, who I'm also extremely grateful for joining me this evening. For many hours, prison health staff had dismissed Jacquie's obvious alarm for the health of herself and her child. Jackie eventually left the hospital in an ambulance late in the evening after the prison health staff had left for the night. Guards put shackles on Jackie's legs when she was brought out of the facility. This is in 2016. In labor to the ambulance, presumably according to what was then standard horrendous practice, since changed. Jackie labored for hours, still in leg restraints, as noted on her hospital chart at Victoria Hospital in Prince Albert, before an emergency transfer to Saskatoon due to a ruptured placenta. This entailed a 140-kilometer ambulance ride, still in leg shackles. These shackles were at last removed in Saskatoon, and she delivered her baby at noon the next day, 6 weeks before her due date in July. Even on her Saskatoon hospital chart, it was indicated that Jackie was to be returned to prison in Prince Albert without her baby upon discharge. She was unable even to avail herself of the, quote, 5 days rule described later, since the appropriate birth plan paperwork had not been filed with social services. However, in what seemed like a miracle, a way was opened. Corrections staff, showing admirable human decency in some last-minute scrambling, identified space in a small Saskatoon facility where Jackie could stay. She was permitted escorted absences to visit Yuri, her newborn son, who would be hospitalized for several weeks. This continued the contact between mother and infant at the key time when bonding and nursing could become established, and also enabled the delivery of pumped breast milk. Late on the afternoon of Yuri's birth, I called the Crown and explained that Jackie's baby had arrived ahead of schedule. I had requested a consent to release under largely the same conditions she had had prior to her sentencing while under house arrest, which would enable mother and son to be together once he was released from hospital. Thankfully, this request was accepted in the light of the circumstances. Ultimately, the appeal resulted in a consent judgment which allowed mother and infant son to continue to be together under a lengthened sentence served under house arrest. Yuri was thankfully not denied his mother's care. Today, I can tell by the pictures that Jackie sends me that her family is doing very well and that their bond is strongly established. Jackie and Yuri's specific story is in the end positive. They were not separated at Yuri's birth and are living well now. Their story reflects what most people, I believe, understand, that only in rare and individually identified circumstances would it be wise to interfere with a newborn's bonding with his or her mother. It was readily apparent that Jackie's case was not one of those circumstances, both in my opinion and those of others familiar with her. The system had to be given pause in its operational assumptions, however, by Jackie's appeal process, in order for this understanding to be acted upon, and in order to dislodge the colonial lens norms in the legal system that had previously worked against Yuri. Although Jackie and her son were able to stay together, I would estimate that every year, a minimum of about 45 other newborns across Canada are unjustly removed from their mothers and denied the chance to bond with them, with profound effects on these children's health and lives. This estimate is based on my access to information requests presented in the next chapter. Changing the legal system feedback loop will require addressing courtroom attitudes and corrections policies. Strong prejudices exist against mothers who have interactions with the criminal law. I recognize the depth of these prejudices after a revealing exchange I had with a professional from whom I had requested documentation in my role as Jackie's lawyer. He was initially hesitant to provide documentation to me, stating that this was out of concern that it could, quote, be used as leverage to keep her out of jail, unquote. I responded that Jackie was very keen to mother her newborn and that she would be unable to do this if in jail. What was telling was how this individual, unprompted, continued. He maintained his position and stated that, quote, foster care is preferable in some cases, unquote. I countered by saying that this was, in my view, surely not one of those cases. I provided details of the offense, the timing, and of Jackie's strong commitment to her son's well-being. Ultimately, the person did provide the information I had requested, but I remained struck by this person's immediate, and sustained insistence that if a jail sentence had been decreed, the consequent denial of bonding and motherly care was automatically of no importance. I realized that this was the key type of thinking that had led to my client and her son's predicament. This person, like so many others, expressed the assumption that a woman sentenced for a crime had no value as a mother. This person also knew Jackie's race. This professional was set to enact the implied determination that Jackie's sentencing judge had communicated earlier, the determination that she was a worthless mother. Two more paragraphs. I didn't mention Jacquie is a First Nations woman with of a Treaty 6 First Nation with close family ties to a Métis community. At the request of the Crown, the sentencing judge had sent Jacquie to jail in her third trimester of pregnancy, with all involved knowing that this would mean that her baby would be removed from her care. This was an unspoken and non-transparent collective judgment determining that Jacquie was a worthless mother and that it was acceptable for her child to be removed, including for placement into foster care. This implicit judgment regarding her fitness as a mother was made at the sentencing stage, and this was the initial legal communication in the feedback loop in action. This implicit judgment sentenced her newborn to be taken from his mother and not to have his mother's care or bond with her. It is this initial courtroom communication that must be interrupted in the legal system. It cannot be made acceptable in this system that a woman's value as a mother is non-transparently declared to be nil. The stereotypes at play, discussed in the coming chapters, must be challenged head-on. The science on newborn health and attachment must be put before the court. Fit sentences should not be premised on assumed worthless motherhood and should include non-custodial options to suit the demonstrated circumstances. Indeed, this is the case for all persons before a court who will leave their children without a caregiver if they are incarcerated. Council should put before the court the clear treaty obligations Canada has to directly consider the best interests of the child in all state decisions affecting such children, including state sentencing of children's mothers. This international law obligation is part of Canadian domestic law, since Canada is presumed to legislate in compliance with its international law obligations. The sentencing provisions of the Criminal Code must therefore be interpreted as including a consideration of the best interests of the child in the sentencing of their caregivers. Two more sentences. Seems like it's all bigger pictures of a fuller picture of the same thing. Automatic separation between mother and newborn here relates to race and history. Like 85%, that is nearly all of the women sent to jail in Saskatchewan, Jacquie is Indigenous. I already mentioned the judge's reference to Jackie's quote, culture, suggesting that the presence of a mother was of little importance in the raising of an Indigenous child, and that a grandparent's presence was sufficient. And as I examine in chapter 7, in Jackie's sentencing, the judge also made reference to the resources that Jacquie had supposedly put towards her college education, which he suggested erased the impact of residential schools from her personal background. One cannot help but notice the similarity of this reasoning to the widely held racist stereotype, which holds that Indigenous people in Canada are spoiled by free education and a quote, free ride in general. So I think I will leave that there. It's supposed to be 10 minutes, and I think I went farther. But still invite Marilyn to come up and we can talk more about everything else. Oh, sorry, I walked away from my technology. I didn't in the reading get too much into the theory, but it's hinted at. So I don't want to overwhelm people with theory. Gosh. Hello. Hello.
So there's a lot of ways that we could talk about this story. We could spend the whole evening talking about Jacquie and Yuri. we could spend the whole evening talking about how a law professor who's an expert in multinational corporate law ends up working on a human rights case and a criminal law case, which she wasn't practicing and wasn't doing. We could talk about the racialized systems that we work in, and we could talk about now what are we going to do about it. So this book is trying to do so many things. And so one of the things that we talked about doing was, you know, you mentioned it already, but really letting people know that Jacquie and Yuri are great.
Yeah.
The end of the book is this mom and this little boy are doing really well. And so do you want to talk a little bit about Jacquie and Yuri?
Yeah, and that's just it, is that a serious problem was averted because people in the system were given pause. And I think that that's extremely powerful to remark upon, that so much change can happen if people just stop and think for a moment and recognize that, yes, they're doing the same thing that's always been done. Yes, it's not exactly their script. They didn't come up with it, but if they're the ones actually implementing it, they have the power to shift the narrative in a really profound way. And in this case, bring up the Convention on the Rights of the Child, bring up health research, bring up the, in my opinion, obvious issue that's about to be a real issue. So yeah, it was a very near thing, but she has risen to the occasion and is on a healing journey and focused on the next generation, right? So kudos to her for sure.
And Yuri's 7 now?
Yeah,
Is that right?
yeah, getting
So,
there. Yeah,
He's a little boy growing up now
Yeah.
in a family.
for sure.
So, is it, get my teacher voice out? Hello, okay, we'll share. So you end up with a call essentially in your office one day. And so the law school has a pro bono clinic. It's not uncommon for these kinds of cases to end up coming through a student or through some other avenue into the law school, so that professors get involved with that. It ends up coming to you and you end up kind of taking this on. So I was working at the law school at the time, and there was a bunch of conversations about like what the heck and what's going on. And in the book, you're going to see that she made a lot of calls to try to get somebody to pick this case up. Like, where are the people? I'd really like you to talk about that, and I'd really like you to talk about listening to the tape of the presiding judge, because you had to listen to the audio because there's no written judgment from the sentencing of Jacquie after her charges. So do you want to talk about that for a bit?
Yeah, two things. There was no representation for her. Legal aid represented her initially, but I'm not really sure why. But for some reason, it wasn't what happened after her sentencing. Probably some sort of resource limitation. So yeah, I called around. I couldn't find anyone, and so that's how it ended up on me. And so that in this book, there's a chapter about the buffers that keep the system in play. And a major buffer that keeps the system in play is lack of representation. People cannot afford lawyers. And if you don't have a lawyer and you're in jail, what are you going to do? You don't have the internet. You have to pay a lot of money to do some phone calls. You're not a lawyer. Like, you're stuck here. And so so that lack of legal representation is a huge reason why dozens of children every year have this happen to them and just automatically get taken from their mothers, because their mothers don't have representation. And there's just this wool over people's eyes, this willful blindness. You know, when she was denied her motion for court-appointed counsel for funds, the motion justice made reference to how she would get a list of pro bono lawyers, and made reference to Classic as if she would somehow nonetheless get representation, even though I'd already tried those, and there were no there was no possibilities there. So there's this self-delusion on the part of pretty much everyone that the system works and that people get representation when they just don't. So that's the representation piece. The other one was about listening to the audio. Yeah, the audio was something else of the initial sentencing, because you could just hear the tone of everyone involved, knowing that, yeah, she was going to go to prison regardless of the fact that she was pregnant 6 months, regardless of the fact that everyone knew that the baby could stay there. It was just a non-issue. It was just ignored. And the judge even said it was a neutral factor. So that's just obvious to me that she's getting treated as a non-mother, just point final, and it's so implicit and such a heavy stamp of deemed worthlessness and dehumanization that no one even acknowledges it because it's just a given. So that's what listening to the audio was like for me, was just understanding the depth of how ingrained and habitual this system is, because everyone involved has the same expectation that this is going to happen. And of course it happens as a result. And I'm saying that shouldn't be the expectation. We've got international law. We've got the Treaty on the Convention on the Rights of the Child. Come on, everybody. Let's not ignore good law.
So did that happen to you right away? Did your academic brain take over and go, what the hell? There's a bunch of law here that nobody's listening to.
It really took me a while. It was after I talked to that professional who just kept on saying, oh, you know, leverage to keep her out of jail, you know, foster care. And I said, it just resonated with me. Why is this person just going straight to that idea when he doesn't know anything? And the reason he's going straight to that idea is because in the sentencing court, or let's say even getting sent before you're sentenced to jail, that can happen, remand. However you end up in jail, sentencing, it's that decision that's being made in the courtroom is the key point in the legal system where the law is being enacted in this implicit way.
And so you're first of all going, oh my God, I got to get help for this woman. And then you're starting to go, wait a minute, there must be some legislation here. Like it sounds like you had this like fast track education into appeals, criminal law, international rights, children, all of it.
Yeah, there was 2 stages. The first stage was like utter panic for the whole, like, I'm an academic, legal academic. I'm not like one of those law professors that's been in the trenches and then talks about it. No, I've never been in the trenches. So this is like me going to well, not even the trench, but anyway, I was really keen to get back to the ivory tower. But so the first stage was figuring out how to do the appeal, which was pretty much hassling everybody I knew for various points along the chain. And also having a lot of help from the Court of Appeal, the Sheriff's Office, you name it. Yeah, you got to do this next. Okay, I got this. Anyway, all this to say that was the first stage. And then the second stage that actually is the whole book was figuring out why is this happening, and figuring out, okay, it's happening because of this decision in the courtroom. And then it was unpacking why that's happening from a colonial lens, which is me going to the library and taking out a bunch of books on colonization, because as an international law person, I didn't really think about that very much. I was just focused on the rule. So it was actually learning more about Canada and Canadian colonialism that brought me to this, the theory and the analysis.
So Robin ends up being sort of this witness to what's happening with Indigenous people very regularly in very many systems, and going, what the hell? Why isn't anybody doing anything or paying any attention to this? And then sense making has to happen for you from that. And so the sense making comes when you get back to the ivory tower and go, like, what's actually happening? So you get this colonial education where, you know, Indigenous people aren't surprised by stuff like this.
No.
Indigenous people are like, yeah, this is actually happening to us, and we're shouting from the rooftops. You know, the Missing and Murdered Indigenous Women campaign that was over 40 years old, where women, just families screaming for someone to see. They're putting our women in jails, they're putting our women in dumps, they're, you know, all of that's happening. And so you step back and you start to put the pieces together about systematically what's happening, and then you've got these two theories. And so the book talks about Jacquie and Yuri, but I'm really interested for you to talk a little bit about what the theories are that you develop and kind of break them into the two pieces that you have. I think people would.
Yeah, I build on the work of a lot of different people. Shireen Razik is kind of the key ideas of how in Canadian discourse and systems, because of colonial justification, there's two really common tropes that are used to dehumanize Indigenous persons. This assumption that Indigenous persons are disappearing or dying just naturally, and then this other one that is that they're uncivilized or savage. And so those two tropes connect to this idea of terra nullius, which is, hey, this land is empty. The people that are there, they're not really there. They're disappearing, or they're uncivilized. So we don't count them as people. So that theorization of dehumanization, I mix that with law as a social system, which sees law as a system of communications, which traces the acts of the legal system down to their specific communications. And so we can trace in the legal system where these tropes appear, or at least are in, they're not always said, but they are actually there and activating what the law looks like. And so what's happening is that the law is permeated with this colonial ideology that's dehumanizing when these tropes are automatically used and applied to Indigenous persons, Indigenous women, Indigenous mothers, Indigenous children. And so in the book, I trace these tropes. I trace the trope of the Indigenous child, the unfit Indigenous mother, the court as this place that puts the quote, uncivilized Indigenous people out of sight, and also and also the prison as a place of inherent dehumanization and where things go to be as trash. So I'm identifying these tropes and the power that they have in legal communications and connecting that to the incarceration of mothers and how their babies are automatically taken away, even though the baby should have due process rights to major decisions. And there's a chapter about the acquittal of Gerald Stanley because of the tropes that were really obvious in the transcripts in that case as well. So that's the theoretical side.
The examples that you use in the book are really profound and they're very relatable to a Saskatchewan audience. You talk about Pamela George and the murder of Pamela George in Regina and what happened to the two boys who were participating in the violation and objectification and eventually the murder actually of Pamela, and how the system participated in it, the journalists participated in it. Another example that was hard for me to read was the Cindy Gladue example. And so we've got an example of an Indigenous woman who's been raped and murdered, and the court thinks it's absolutely okay to have her vagina removed and put into evidence, and nobody talking about how that is so far past anything that happens in any other non-Indigenous case and doesn't come up on appeal ever. Nobody's sort of talking about those things. And then of course the Stanley decision and so the examples are really hard hitting in the book, and it feels like a wake up. It feels like we have to pay attention to what we're doing here. And the other systems theory piece that you talk about is the positive and negative sort of loops that happen and how they kind of feed into this institutionalized racist system. Do you want to just talk a bit about what those loops are and what they do?
Yeah, so how a systems theory works is that it's a very self-referential system. So you do what the system tells you to do. You continually check what the system rules are, and there's specific rules for how to actually change the content of the system. And so negative feedback loops, it's just like your thermostat in your house. It's stasis. You do the same thing over and over and over again. That's what you always do. Positive feedback loops are when you're amplifying change in the system. It's like climate change where all of a sudden there's no snow to reflect back the heat. Instead, the ocean is absorbing, and so things are getting warmer and warmer. So for feedback loops in the legal system, the incarceration of Indigenous persons, like more and more and more Indigenous people are being sent to prison. That's a positive feedback loop. Not positive in that it's good, but positive in that it's amplified change. It's like continual expansion of a certain cycle. So that's how feedback loops are referred to in the book.
And I just want you to talk a little bit about sort of in the systems theory, you've got sort of three things that you talk about is what's happening with the lack of lawyers, the lack of diversity within that, and then the lack of public outcry from it. Do you want to talk about that?
Yeah. So what keeps the systems in play? There is the fact that people don't have access to legal representation to bring their voices to bear, to be heard by the system. That's one buffer that keeps the system in play. Another buffer is that the people that are in charge, more or less in charge of the system, the ones making the laws, the ones enacting the laws, the ones stating the laws, the lawyers, the judges, the politicians, the key civil servants, the key administrators, there's not enough diversity of experience and worldviews, and so there's a lot of shared implicit biases amongst people in those positions because there's not enough diversity of voices to challenge entrenched assumptions. So that also contributes towards the system maintaining its stasis. And then the fact that there's no written decisions for most sentencing means that no one's really aware of what's happening in the courtrooms. You would have to sit in a courtroom all day to know what a courtroom is doing. You could get, yes, they're public, but you would have to have a specific case number and pull the information for a specific case number. There's no aggregate way of knowing, for instance, how many pregnant women are sent to prison in Saskatchewan. It's not publicly accessible in that sense. A very, very small proportion of sentencing decisions are published and accessible online.
So the book alludes to there are some programs that are available across the country, and that more information, more education, more finances have to go into these programs for babies in jail, pregnant moms in jail, and what can happen with that. And so you have to go read the book. They're on the counter over there, but we'll jump over top of that and talk about, you know, you could write about this and you could say, this is what happened. And one day in my office and I got this call and I met this family and this is what happened to them. And this is what's wrong with the system. And you could have left it at that, but you did not. And so the next piece of your writing is very much a wake-up call for the system. So when this system, this dysfunctional, racialized system is just doing this over and over and over like a machine, you're saying somebody's accountable here. And what I love about the writing is you say the people who aren't applying law that they are perfectly aware of and capable of applying have to be held accountable. That's huge. That's just a huge ask, and we aren't used to asking for things like that of judicial actors or legal actors at all. They have a huge amount of discretion and they have a huge amount of protection. So this could be like what is she asking for? So I really want you to talk about sort of that. Now what? Now that you've seen it, now that you're telling everybody about it, what needs to happen now?
Yeah, it's meant to be a solution-oriented book. It's meant to say, okay, first of all, no shackling in labor, 100% against the woman and the child's constitutional rights, right to security of the person. Cruel and unusual punishment should be a non-starter, but there's not a lot of clear rules to the contrary in Canada, and there should be. Aside from shackling, the automatic separation itself, I keep mentioning the Convention on the Rights of the Child. That's clearly applicable both in the courtroom and later vis-a-vis the correctional actors, but also the Charter itself, security of the person, the child's right to security of the person means that they are entitled to due process when they're to procedural justice when decisions of this magnitude are taken by the state. And it is a massive decision to be taken as a newborn from a caregiver that would, in most circumstances, be available to initiate bonding and all of the development that happens with that. So that's a massive decision with regard to health that cannot constitutionally be taken in a automatic fashion. So I think that at those 2 points, we bring in the charter, we bring in the Convention on the Rights of the Child.
Okay. It's time for audience participation. So whoever has some questions about sort of what this is, the family, what Robin is thinking about it, where her writing might go next, would be great to hear from you. I'll give Jasper the mic.
I'll be the microphone gopher and run around if you have a question.
I've often wondered since I read about the Stanley decision, have you had any blowback from people?
No, I mean, I haven't. It's not. It's usually usually it's just kind of a quiet assumption. Well, of course that happens. It's prison, which is the whole point of the book. Which is, yes, I know. That's how everyone seems to define prison. And I'm saying maybe we shouldn't just define prison that way. Let's bring in some humanized definition of people. So it's not really surprising interactions so far.
Hi, Robin. I'm so excited about your book. Congratulations. So I grabbed a copy, and every time every book I pick up, it's a thing I always do. I always read the last sentence first. It's just how I read. And so I looked at the last sentence, and the last sentence has something to do with this book doesn't propose radical changes. And that got me thinking about abolition and whether really the solution is to not incarcerate mothers, and whether you kind of thought about that or why you decided to take the tack of looking at sort of like changes within the existing system.
Yeah, that's a great question, because in doing this work, I've come across a lot of abolitionist writing, and I certainly identify with pretty much everything I've read in that ilk. But I didn't even feel I needed to go all the way there. I was just saying, and I have a statement in here where I say that, you know, there's a question as to whether or not incarceration is even useful in reaching its demands. But in terms of the bigger picture, I don't go there, because I'm not even asking that much. I'm just saying, let's not just have this extreme rights violation in this instant. But I think that that abolitionist scholars have it right. Everything I've come across.
Any more questions? Turning circles up.
Hi. So it seems like a huge piece of this book is around access to justice, both for the mothers and also for the infants, right? I'm just wondering if you can speak about how you can see improved access to justice through this lens and through this process.
You know, there's structural questions about increasing legal aid and other means of, you know, having people on site in the prisons available to everyone who needs, you know, that is, in my opinion, necessary. And then, but aside from that, I think that the narrative from prosecutions and from the Ministry of Justice has to shift towards being open to taking childbirth more seriously, taking motherhood more seriously. And if that happens, I think the types of sentences being asked for will change. So the access to justice piece could be met with institutionally, but I think there could be more access to justice just with different types of sentence requests.
What kept you going?
What kept me going? I don't know. I'm stubborn, stubborn Hansen. I don't know. That's a good question. It's one of these things. I mean, probably in your work too, the work sort of just keeps revealing itself to you and kind of gets bigger and different. And actually, I'll give a shout out to the peer reviewers. They really helped me because it was a new area for me, and so that kept me going to try to reach to what they were saying. Hey, you got to go there. This is necessary. So just responding to what people said.
Congratulations, Robin.
Oh, thank you.
It's really exciting that this has come out, and I actually feel like I remember being in your office when you were in communication with Jacquie and trying to begin to find your way through this. And so I have two questions. One is, at what point did you realize that this wasn't you just being an activist and an advocate, but actually being able to make this an intellectual, scholarly sort of research contribution? And then my second question is, you mentioned, you know, this is something that Canada does, right? They just take babies away from their mothers when their mothers are incarcerated. And I wondered if in the process of doing the research, you found other jurisdictions where they have different practices that maybe are better, and whether you brought that into the work or whether it's just something that maybe Canada needs to be like thinking about in terms of fixing this disaster.
Yeah, so yeah, most of Western Europe, Northern Europe, they think about these things. They have systems in place. It's not this, it's a different societal reference point. They're doing different things in their society. They don't have the same, I mean, the book gets into the fact that this is a huge part of colonial apparatuses in process. And so that's part of why we're doing it this way in Canada. And I should note that BC has a mother-child program. Northwest Territories, there's prison level, facility level accommodation. There's less separations recently in Nova Scotia, just I think ad hoc, according to the access to information requests. And then there's the underused federal mother-child program, but it's all the rest of Canada that this is happening. So in Ontario, my first access to information request was for a 5-year period, and there were 26 separations in Ontario in that 5-year period. So it's happening a lot. So to answer your question, yeah, it's not like this in all of the world at all. And the other point you made about when I realized this was going to be an intellectual project, I'm just laughing because I had so many exchanges with so many of my colleagues saying, what am I going to do with this? You know, what, like, I'm an international law scholar. So you just have to read enough and then you figure out where the center of gravity is. And as I said, other people talk to me, and I think the beginning of COVID is when the last, close to last version gelled. One more question? Sure.
Someone had a hand up here.
Well, there's one back here.
Since you mentioned the Convention on the Rights of the Child, are you aware whether or not this issue has been appealed to the Committee on the Rights of the Child?
Yeah, the Committee on the Rights of the Child is at present doing a report looking at access to mother-child programs and what circumstances should govern admission to these programs. So it's a live issue before the committee right now because of the denial of access to these programs being seen as a problem at the committee level. There are many state reports, many communications from the committee in response to state compliance reports denouncing the lack of mother-child programs and automatic separation due to sentencing. So it's a live issue at the committee level.
We have time for another question or two if anyone still has something burning in their mind.
Well,
Or will
those
we?
are theirs.
Oh, here.
So at a practical level, Robin, it sounds like a key audience here is prosecutions. And I'm wondering at the ground level if you've had any responses from prosecutors, prosecutions in any interest in learning to think differently about this. Ultimately you talked about judicial decision makers, but the tools for good decision making are often left to the lawyers to put to the judge, and I'm wondering what the next steps might be there. It sounds like you have a bit of a call to action in the book.
Yeah, definitely. I haven't had any communications, but I think I think that's the logical next step, along with defense counsel as well, and because I 100% agree. It's what's being put before the court to a certain extent, and that has to change. Sadly, it's that's where the habitual nature of what's happening needs to be questioned. Well, thank you so much. I guess that. Oh yeah.
I started by saying there's 1,000 ways we could have talked about this tonight, and now you've just got a taste of sort of 10 of the things that you're going to find in this book. So I really encourage you to pick that up. One of the things that happens, just to add on to Michaela's comment there, is it's not just the justice system. Education systems are like this, and medical systems are like this, and our healthcare systems are like this. And so the women that we're talking about in this particular instance are finding this in every system that they go to. Hospitals are participating in taking babies away. Social services are participating in taking babies away. And so it's a big question, but I love that Robin just goes in and says, look, if you just do your two things, if everybody just did their two things, that we could actually move mountains. And Gladue reporting, there's a ton written on Gladue reporting and how we know there's a systematic issues. What are we doing about it? That's over 20 years of trying to do that within the criminal justice system. And that there's 1,000 threads. And so Robin, if you want to just sign off with, it's not over, is it? Like you're not going back to multinationals for the rest of your career right now. That it's not over.
No, it's definitely not over, and I think that there's a lot of interest among people working in these areas to do some shifts, and I think that it's entirely feasible for there to be some good shifts because there is a lot of goodwill and a lot of reporters that can be harnessed. So thank you so much, everyone, for your interest and participation tonight. It's so greatly appreciated.
She didn't have to do this. She didn't have to pick up the pen and make it an issue and ask us to wake up. So I just really want you to all say thank you to Robin for being that voice. It's going to be a lineup for book signing pretty quick.
Sure, yeah,
So you want to line up for your book?
All right. Thanks, everyone.
Okay.